Hello and welcome back to another update in the Vallow Daybell case. This is for today, March 23rd, 2021. Now we saw a hearing yesterday, so we're going to break that down because it was a little confusing, and then we're going to talk about a bunch of new documents that we got this morning. So let's get right into it. First off, one of the biggest questions we have about this hearing is why was this just about Chad? Doesn't this apply to Lori's case as well? Well, let's listen to the opening of the hearing where the judge pretty much explains it. I missed it when I was listening to it live because I was a little distracted, but here you go.
We took up some housekeeping matters prior to this hearing, and based on our discussions, the motion was filed in both cases for pro hac vice admission. The court's going to reserve argument or ruling on the issue in regards to the Lori Noreen Daybell Vallow case, which is the 838 case. And we will go forward with the motion as it relates to Mr. Daybell.
Well, that certainly explains that. If you remember, even though the trials are joined, each defendant has a separate case. If you look on the screen, Rob Wood filed two pro hac vice motions, one for Lori's case and one for Chad's case. So the hearing that we saw yesterday was just about the pro hac vice motion for Chad Daybell's case. Why would they not have heard both of them in the same hearing while they were all there? Not entirely sure, but I think it has something to do with the objection that was raised by Mark Means, and we'll get to that later on in the video. The next issue that arose was the question of whether or not Rachel Smith had maintained an active legal practice in the state in which she is licensed, Missouri. Now that is a valid legal question, and from what the judge says in the next clip, Rob Wood failed to include that in his motion, so the judge was bringing that to the floor. We'll get to his response in just a minute, but here's what the judge had to say about it.
Commission Rule 227, that governs our pro hac vice admissions in Idaho, and one of the requirements is that the attorney seeking to be involved in the case would need to, under Part A2, currently maintain an ongoing law practice in another jurisdiction. So I didn't see that information provided in the motion, and the court would need to have this attorney has an ongoing law practice in another jurisdiction at this time.
Later on in the hearing, John Pryor revisits this issue and they have another discussion about it. So these clips are a little bit out of order, but let's listen to what John Pryor has to say, and then let's watch what Rob Wood does in a beautiful, smooth move that I thought was just brilliant. It was very smart of him to have Rachel present for this hearing, and let's see how that played out.
The other issue I have is this, Judge. I've done some research on Miss Smith, and the information I have, and I don't want to suggest that my information is complete, but the information I have is that she's a consulting firm and that she does not have a practice, an active practice. Now, she's licensed in Missouri, but I need some sort of declaration from Ms. Smith saying, yes, I am actually practicing law in the state of Missouri. And
In this case, I actually have Ms. Smith is here with me right now. I can have her make a declaration to the court of her law practice, or if the court would prefer that in writing, we can do that as well.
Well, if she's here and available to testify, I think that's probably the most efficient way to do that. Good afternoon, Ms. Smith. This is Judge Boyce. Can you hear me okay?
Yes, Your Honor. Good afternoon.
I love that beautiful slide in. Just turn the camera and there's Rachel Smith sitting right there. That was a good move. So she was able to testify and say, yes, of course I have an active practice. It seems to me here that the defense team really needs to brush up on their internet sleuthing skills. Perhaps we could teach them a thing or two. Anyway, moving on. This next short clip is just something that really irked me personally. Here's a clip of John Pryor being an absolute condescending twit to the judge.
Judge, you addressed the very issues that I had concerns with as well. You were astute enough to recognize the two things that I find problematic.
Boy, I'll tell you what I find problematic. Anyway, the next issue to bring up was almost like a jurisdiction issue. Rob Wood is the elected prosecutor of Madison County and also named the special prosecutor for Fremont County. Now, he brought in Rachel Smith and got permission from the Madison County commissioners, but not Fremont County. But technically, the case is in Fremont County, and it's a little bit confusing. John Pryor goes into his argument here. He does make kind of a point. However, Rob Wood explains it at the end, so let's take a look at that.
One, that this is a Fremont County case. And as a Fremont County case, Mr. Wood, obviously, if his prosecutor's office wants to retain people to help him with his caseload, he has every right to seek whatever resources he wants to do that. And he can obviously hire anybody he wants. He's the chief prosecutor in Madison County. But this court identified the very issue of the Pro Hoc rule. And the Pro Hoc rule is case specific. And as a case specific rule, he does not get to enlarge, retain someone and say, you're going to handle all of my cases, and you're going to train my staff, and you're going to teach us how to properly prosecute cases. That's not something that he's prevented from doing. But in this particular case, he's prevented from having Ms. Smith participate unless Fremont County gives them their blessing, and that they're agreeing that Ms. Smith may come on, that Ms. Smith may participate this, because he's not the Madison County prosecutor in this case. He's the Fremont County special prosecutor.
We've discussed it with Madison County. They're funding it. And so we did not speak directly with the Fremont County commissioners on that.
So basically, Rob Wood is saying, hey, Madison County's paying for this. That's who we asked. That's my home jurisdiction, so to speak. And Fremont County is not paying for it. And he is the special prosecutor of Fremont County, so he kind of has jurisdiction over both, and it's fine. The judge agrees that, yes, this is fine and everything's great. However, the next issue is all about the funding. A lot of people heard during the hearing, it sounded like Rob Wood said he wasn't being compensated for this case. But what he means is he's not being compensated by Fremont County. The funding for this case, as well as for Rachel Smith's involvement, is coming from Madison County. So let's take a listen to that.
Thank you. Mr. Wood, do you have anything further to offer in support of the motion?
Yes, Your Honor. As the appointed special prosecutor, I'm allowed to prosecute this case as I see fit. I'm not asking Fremont County for the money to hire Ms. Smith. And as such, I don't think the court needs to make a finding that I've gotten it approved for the Fremont County commissioners. If I'm not being compensated for this case. If we were asking them for money, I could see that being an issue or not.
I hope that clears up that confusion a little bit. The last point of business is the judge asked Rob Wood to file a certain declaration just so that everything's, completely on the up and up with Rachel Smith's involvement. I'm sure he'll file that in the next day or two if it hasn't been filed already. And then we set the status conference for April 7th, which we already knew was coming. And hopefully that will be live and we'll hear a lot of interesting points. Although I think that might be behind closed doors. We're going to have to wait and see. Now, let's talk about Mark Means' objection that was filed in response to the Pro Hac Vicee motion by Rob Wood. I'm going to put it on your screen, point out some highlights, and then let's go from there. Alright, so Mark Means filed an objection to the plaintiff's motion regarding the Pro Hac Vicee admission. And the entire document is up in Discord if you want to read it. Let's highlight the different arguments that are put forth in this motion. Number 1, barred from hearing motion. Motion is barred, suspended, from hearing as a result of previous court orders. That's interesting. I have some thoughts on that, but I'm going to withhold them for now because let's just wait and see what that's all about. But what he's saying here is that there's something before the court. There's an order before the court that would be preventing a motion like this from being dealt with. So what could that be? I'm not sure. Let's move on. Number 2. The court lacks jurisdiction to grant the motion. I don't know about this. What he's saying here is that because there are no murder charges or capital offenses in this case at this time, Rob Wood would have no reason or even jurisdiction to bring in someone like Rachel Smith. Now, I can see that point. He says the phrase cart before the horse twice, which you heard Jess and I say just yesterday. So I kind of get that. I'm not sure if that's a legal argument that he can put forth to use to prevent Rob Wood from bringing in Rachel Smith, but it's certainly a valid philosophical argument. Number 3. The waive righted. Yeah, something was waived here. Prosecutor Rob Wood is the public prosecutor from Madison County. He's elected and obligated to perform the prosecution of crimes. Okay, so I think that his argument here, again, this is philosophical more than a legal argument. Basically, he's saying Rob Wood was hired to prosecute crimes. This is his job. If he can't do his job, he's going to turn around and bring in somebody else to do it that's going to cost the taxpayers a lot more than they agreed to pay Rob Wood to do this job? But he also says that there are other remedies available to Mr. Wood if he's having trouble doing his job. The state attorney general's office, the Fremont County prosecutors, there are other things that he could have done before leaping all the way to Rachel Smith. Now, okay, philosophically, I may agree with that. Legally, I don't think this is going to sway the judge in either direction. It seems to me that Mark Means wants this on the record for a reason. So, number 4. Lack of grounds asserted to grant the motion or lack of expertise. Mark Means says there is no grounds whatsoever before the court asserted by Mr. Wood regarding Miss Swift's qualifications in assistance with concealment or conspiracy to conceal cases. That is a point. Okay, legal argument or not, I don't know. But certainly, and I even said this myself yesterday, you don't need Rachel Smith to prosecute conspiracy to conceal evidence charges. She's not needed. So clearly, this is going to have something to do with murder charges. But then again, we go back to Mark's earlier argument that that's the cart before the horse. Okay, I see where he's going with this. I do. But again, I'm still not convinced this is a legal argument. Number 5, the precedent. Now, this is an interesting paragraph. Mr. Wood is asking the court to set a dangerous precedent. That precedent being that when a public county prosecutor, elected and compensated for performing this public service, is unable, incompetent, or unwilling to prosecute a case, that said public servant shall have the rights at public taxpayer expense to hire private out-of-state counsel to prosecute a case with a blank check obligated for payment by the taxpayers. Okay, I mean, it's really hard to disagree with that. It really is. However, legally, that doesn't really carry a whole lot of weight. So, I'm seeing a struggle here, because I agree with the principles behind these arguments, but I don't think legally these are going to be valid as an objection to the pro hoc vice. We'll have to see what the judge thinks. Moving on, number 6, notice of intent, conflict of interest, and implied waiver. Here he's getting into the fact that, as he has asserted several times before, Rob Wood is already an essential witness in the matter, in the case for Lori Vallow Daybell. Oh, this is tough. This is a tough one. Number 1, this really doesn't have a whole lot to do with the pro hoc vice for Rachel Smith. This is something that Mark Means just wants on the record again. All right. But, is there a situation in which he is going to call Rob Wood as a witness? Quite possibly. Is that going to present a few problems for the case as a whole? Definitely. So, now we have to see what's going to happen with that. He says here in this argument that these communications are not protected, and thereby it's an implied waiver of any following objection for any forthcoming counsel pro hoc vice with communications between Wood and Smith, etc. Ooh. We're going to end up back there. We're going to end up back in that argument with Garrett Smith and that recording of Summer. It's not going away. So, I'm sure you all have a lot of thoughts about that. So that's the overall issues that Mark Means is raising. Like I said, I agree philosophically with a lot of it. Is that going to give him legal grounds to block the pro hoc vice? I don't think so. I don't think these are legal arguments, but they are maybe, in Mark Means' mind, moral, ethical, or philosophical arguments, which I can agree with. I don't think this is going to work. I think they'll have their hearing, and I think the judge will say, yeah, okay, you made your point. But legally, he's allowed to do this. Here we go. We ruled. It's done. So we'll have to wait to see when that hearing is, or if they're just going to discuss it behind closed doors and get it done. But there you go. There's the filing. It's up in Discord. If you want to read it, you can go there. One other filing that I have for you today, and this was filed by Rob Wood. Rob Wood is arguing again about the discovery. You should see it on your screen. That recently, they've been going back and forth on discovery forever, and apparently it's not going to stop. The judge ordered Rob Wood to turn over certain pieces of discovery that were requested by the defense. They had a hearing about it because Rob Wood wouldn't do it, so they go to the judge, say, Judge, I really need this. And the judge says, yeah, Mr. Wood, you got to turn that over to the defense. Here's a list of what you need to do. Go ahead and do it. And now here's Rob Wood saying, but I don't want to. So, this is just an ongoing battle. And we're probably going to see more of this. So we're probably going to have a hearing, another hearing on that, another motion to compel. That may come up in the conversation at the April 7th hearing, but hopefully we'll bring that to you live and we'll see what happens. So that's all that's going on for today. I hope this all makes a lot of sense to you. Anything big breaks, I'll go live, so please subscribe and hit that notification bell. If you have any questions, leave them in the description or in the comment section below. And as always, you can join Discord. It's totally free. We're having a lot of conversations about the case over there. So thank you for watching. I'll talk to you all soon, and have a great day.